Hello, my name is Timothy Roehrs. I'm a partner with the Carlson law firm working in the Mass Torts Department. I'm here to answer a few questions about court structure and jurisdiction in mass torts litigation. So what is the difference between state court and federal court? Well, when you choose, or fortunately are forced to maybe file a lawsuit against a person or an entity, there's an election to either do it in state court or federal court. And it really all depends on who the parties are and what's the type of case involved, which will either put you in a state court or in a federal court. Often in the mass torts world, we're working within the federal court system. The reason that is that these cases usually involve a foreign entity. What I mean by that is a company from a different state than where you're at. And when you have that type of scenario, you end up in a federal court system because you have parties from different states. And then you can take advantage or use the MDL system. So why does a case originally filed in one state when it gets wrapped up in the MDL system, get transferred, renamed, and then put into a different case altogether in a different state? Well, in the MDL structure, an MDL is a multi-district litigation. It involves cases that become so complex or so large that instead of taxing the federal court system with all this litigation, the cases are consolidated into one court. And what that means is that if you file a case properly through the normal channels in, let's say, in California, and you're a California resident, so you file in federal court there, but there's an MDL that exists in Florida, well, that case would get wrapped up and then moved to the Florida MDL. It's a way to help the efficiency of the court system and to lower the cost of the parties litigating cases. So what is the JPML? JPML stands for the Judicial Panel of Multi-District Litigation. It is an entity of judges that decides whether or not an MDL will be formed in a certain type of case. Every so often, there's hearings in the JPML to decide on whether or not a case should qualify for an MDL. This is a way to consolidate things, and that you have to do so through a hearing in front of that body of judges to decide. So if we wanted to create an MDL, we couldn't just decide on our own with a number of complex cases to file and say this is now an MDL. No, if you're in the federal court system and you're trying to get an MDL started, you need to go to the judicial panel and ask them, or they can on their own decide, that an MDL should be created. And then it'll move to whatever jurisdiction that the JPML decides that it should go. What is a bellwether case? As soon as an MDL is formed in a particular litigation, the parties will look through the litigation and decide the best way to approach it. It's different than any other litigation where you might have one party against another party with one claim involved, or just a small set of claims involved. This involves quite a number of people on one side of the case, usually a bunch of plaintiffs going after one defendant. And so what there has to be is some sort of logistics, administration on how to handle all that. And one of the things that they've created is called a bellwether trial. It is essentially the first trial run to see how the case goes through litigation. That person or set of persons that is selected for the bellwether trials are the first trials in that litigation to see how it goes. And it doesn't mean that if that case resolves favorably for the plaintiff, that all plaintiffs' cases will be resolved at the same number. Like if they go get a judgment for a certain sum of money, doesn't mean everybody gets that sum of money, or even that it's split. It just means their particular case ended with that result. And so therefore, everybody can look at it and say, what does the future hold for this litigation? And it becomes a settlement negotiation tool between the parties. What is a PFS? A PFS stands for Plaintiff Fact Sheet. And most cases that go through the MDL system have something called a plaintiff fact sheet as a part of the requirements to participate in the litigation. In a normal litigation, we have things called discovery where we exchange information between the parties. Because of the MDL, there is kind of a shortened version of that, although some of those fact sheets can be long. There's a shortened version called a plaintiff fact sheet, which is a way for an agreed amount of information to be conveyed between the parties. So all plaintiffs that participate in an MDL will have to complete this form, and it will be submitted to defendants. And it's important to know that that document is not just a questionnaire to give to your attorney. It's actually a questionnaire that's going to be produced and usually signed off on by the plaintiff to send to the defendants. It's your testimony and acts a lot like discovery. But it's something very particular to the MDL system or in complex proceedings that have multiple parties involved. Whether you're in state court or federal court, there are different tiers or levels of court. So typically you have the lower level, which is the trial level of the court. It's where you go in front of a judge and jury, and there's another person or company on the other side, and you have a trial and potentially resolve your disputes there. The next level up is the appellate level. Court of Appeals, there's the circuit courts in the federal court system. Essentially, if there are issues at the trial court level, then you, usually involving law or the application of law, you can go to the appellate court to try to resolve those issues. It doesn't have a jury, so those things you see on TV related to trial court with a jury, that doesn't happen at the appellate court. That's where you go in front of a judge or a group of judges to figure out what the law is and how it should apply in that particular case. The next level up after you go through a court of appeals or the circuit court if you're in federal court system is a Supreme Court or a court of last decision. And commonly you'll hear about the U.S. Supreme Court. It is very rare that you go directly to a U.S. Supreme Court on an issue. Usually you have to work your way up the trial levels. The Supreme Court usually only hears things when there is disagreement between the various jurisdictions underneath it. So if you have differences of opinion in one circuit court based in the south of the United States and another one in the northwest, there's a disagreement on how the law should apply in a particular case, the Supreme Court will resolve that issue. But the main thing to remember is that cases usually work their way up through those systems to make a final resolution on a case. Oftentimes cases, if they are complex or there's a lot at stake, will go and use the appellate process, which is helpful to make sure the law is accurately applied, but also can take time, which will slow down any litigation. We hope that the answers to these questions will be helpful for you in understanding the process of pursuing your case or any case for that matter through the legal system. We know that it can be complicated and there's many steps and strategies that attorneys can use or parties can use. We want you to know what's going on within your case because always we care and we can help.